So you have the facts of the case, then the Donnelly case from the previous video, part 2, right? Henry Donnelly was this young kid who had been born with Down syndrome and with other very serious and significant medical complications. The advice was he couldn't go home. He had to spend his life, really, his early life, in hospital. The dad had to care for him while in hospital. That was the medical advice to the family. As a result, the dad has to give up the job. He's spending 5 days a week in Dublin, while the mother, Henry's mother, was at home minding their other children, and they'd swap at the weekend. The family were in this very, very, very difficult situation, financially and otherwise. And under this piece of legislation, or these provisions of the Social Welfare Consolidation Act 2005, the family were not eligible for this payment, this social support, the domiciliary care allowance, which was worth whatever. I don't know what it was worth, but let's say it was worth €1,000 a month or €2,000 a month or whatever it was. They didn't qualify for one reason. The child was sufficiently seriously disabled. It was not a means tested payment, so the family would have qualified. The reason that they didn't qualify was that Henry was being cared for in hospital, right? Whereas under the scheme, under the legislation, the requirement was, in order to qualify for the payment, that you would be caring for your child with a disability at home. I think the idea was historically that its purpose was to encourage families where there was a child with disabilities to care for the child in their home and community rather than have them off in an institution where possible. That was the idea. But as far as the Donnellys were concerned, of course, this was discrimination such that there was a breach. The legislation was inconsistent with or breached Article 40, Section 1 of the Constitution. Essentially, their argument is, look, why should we not qualify? We're in the same situation as these other families who do qualify, in the sense that our child has this very serious disability. It requires this extraordinary care on our parts. We're providing that care in a hospital, not in a home. What's the difference? So it's irrational. Actually, they argued, one argument they ran when their lawyers ran, was that even if the test of rationality, which I talked about in the previous video, applied, that the legislation fell foul of that test anyway, that it was indefensible, and they say it was irrational. Why would you treat these two different categories of persons or families differently? But I suppose that was a difficult argument to win. It was difficult to win, I suppose, for two reasons fundamentally. One, we've already gestured at or considered, and that is that I suppose there was a rationale for the legislation. Certainly the state's lawyers argued this, that the rationale, the purpose of the legislation, the goal was to encourage and support, families with children with disabilities to care for their children in their own homes and in their own communities. And that was a legitimate public interest goal, if you like, and the state was entitled to, or had good reason to, or at least had a reason to, in that sense, discriminate in favour of, if you like, that particular category of citizens. And I suppose the other reason that it was a difficult argument to win for the Donnellys was that, however cold an analysis this might be, the truth is that in the case of a child with a disability who's being cared for in hospital, the state is already incurring a cost, even on matters like, even feeding the child and heating the room and so on. The state, the government, is already incurring a cost for those matters. Whereas if the child was being cared for in their homes, well, then the government wouldn't be incurring that cost and the family would be, which is another kind of a reason or justification, if you like. That's not to say, again, that the discrimination is right, necessarily. Rather, it is to say that it's a reason supporting the rationality of the legislation. Hence, it was very, very difficult for the Donnellys to win the case on the basis of the established rationality test, on the basis of Henchy's test, if you like. So their lawyers therefore had to run a kind of an additional argument, and it was the more interesting, or maybe more ambitious argument, and that was that the rationality test shouldn't apply. I suppose the argument, and again you should read the judgment to pick this up yourselves, but seemed to be fundamentally that this was ultimately discrimination on the basis of disability. And as such, given how significant that is or serious that is, in other words, it's a kind of something that goes to the core of the human personality, or human dignity. It's a bit like discriminating on the basis of, let's say, religious belief, or on the basis of even ethnicity, or sexual orientation. And in those circumstances, that it's appropriate that the court would lower the threshold for judicial review or judicial intervention. Therefore, they argued that the appropriate threshold or appropriate test for analysis on the part of the court ought to be one of proportionality rather than rationality. Now, of course, the proportionality test, the proportionality framework, is the one that's applied in other rights cases. That is to say, in rights cases other than Article 40, Section 1. If you were to bring a case against a provision of legislation on the basis of that it breaches Article 40, Section 3, for example, the right of the person or on personal rights, or Article 44, for example, on freedom of conscience or freedom of religion, typically, normally, the standard test that would be applied by the courts is the proportionality test. So why, say the Donnellys, why should it not apply in the cases of, in Article 40, Section 1 based cases? Now, that argument failed, as we'll see. One of the reasons it failed was that the court disagreed that this discrimination was based on disability. It wasn't based on disability. They said, look, the payment is being made available to families with children with disabilities. It's just, it has to be that the child is being cared for in the home. So the discrimination is based, the difference in treatment is not between children with disabilities and children without disabilities. Rather, it's on the basis of children being cared for in their homes rather than children being cared for in institutions or in hospitals. So that was one of the reasons why the courts kind of rejected that argument. But there's another maybe more important or maybe more general reason which we'll look at, I suppose, momentarily. That was the first main argument. I suppose it's the second main argument that the Donnellys ran. The first was that it was irrational in the first place. The second was that if it wasn't irrational, well, then the rationality test wasn't the appropriate test. Then the third, I suppose, the third argument they ran was, again, a little more technical, that the onus of proof should shift across to the government. Now, again, it's related, right? They said, look, this is discrimination on the basis of disability, they said. Lawyers for the Donnellys said. And as such, given the seriousness, given that this goes to the core of the human personality and human dignity and so on, the onus of proof should shift to the state, to the government, essentially, to their lawyers, to bring to the table arguments in court as to why the discrimination was justified, why it was okay, rather than, as was the established kind of arrangement, that they, the Donnellys, the litigants, would have to bring arguments or evidence maybe to the table to demonstrate why it was that the difference in treatment was not justified. In other words, the Donnellys said the onus of proof should shift to the other side once we show a prima facie case of discrimination, which we have shown, of course. Now, the difficulty with that argument was that it ran counter to the doctrine of the presumption of constitutionality. We looked at the doctrine of the presumption of constitutionality in the last video. I'm not going to look at it again, but if you think about it, the doctrine of the presumption of constitutionality, first of all, it's really well established. I mean, it's not really questioned as a doctrine that makes sense in the context of the Irish constitutional infrastructure, right? And it says essentially that it's up to an individual litigant to show or demonstrate a clear repugnancy when they challenge legislation, that the courts will work on the assumption initially that the legislation is consistent with the Constitution. So you've got to show us why it's inconsistent with the Constitution. So the Donnellys' argument, I suppose, would have required a kind of a radical move on the part of the court, and ultimately it was one that the court wasn't willing to take. And that brings me to what I would see as the kind of heart of the judgment, the O'Malley judgment in Donnelly. It's the bit where, and she does it in about 10 paragraphs, from paragraph 160 to 170 of her judgment, where she sets out reasons as to why, in her view, in the view of the court, the rationality test is the appropriate test, that it would be inappropriate for the proportionality test to apply in what she calls pure equality-based claims. In other words, claims based purely on Article 40, Section 1 of the Constitution. And essentially what she says is that those cases are different in character from, let's call it, conventional rights-based cases in Irish constitutional law. In other words, cases where the claim is based solely on 40 Section 1. Other cases, you take, for example, and these are my examples, a claim based on Article 40 Section 3 of the Constitution on the right of the person or personal rights. Or let's say, for example, a claim based on Article 44 on freedom of religion. Let's just to take an example, and this is my example. Let's suppose that the Oireachtas enacts legislation that bans the wearing of religious signs or insignia in public places. In that kind of a case, the proportionality test would apply. And O'Malley says, even though she doesn't use that example, I stress, that it's entirely appropriate that the proportionality test would apply in that kind of a case, because that's a kind of a case where we proceed on the assumption that there is an interference with the constitutionally protected right. This legislation bans the wearing of religious insignia, which kind of obviously, on the face of it, interferes with the right of freedom of religion in Article 44 of the Constitution. The question is whether that is justified, whether it's a proportionate interference with the constitutionally protected right. She says pure equality-based claims aren't like that. They're claims where the argument is where essentially legislation has been enacted that doesn't impose a burden on a particular category of citizens, but rather confers a benefit on a particular category of citizens, and I suppose draws a line around that category and excludes everybody else from the benefit. And the thought is that if you were to apply the proportionality test to those kinds of cases, then you would be kind of proceeding from the assumption, or the court would be, as she puts it, the court would be commencing its consideration on the basis that the drawing of such distinctions by the legislature is in itself at least a prima facie breach of the right to equal treatment. And that is a kind of an incoherent point of departure, I think, because, well, and this goes back to a point we made way back in the first video, that drawing distinctions between categories of citizens is an inherent or intrinsic part of the process of legislating. And if the proportionality test is to be the test in pure equality-based claims, such as this, well then a court, whenever there's a challenge, will be starting on the assumption that the line that's been drawn by the Oireachtas is unconstitutional, is an interference with Article 40, Section 1 of the Constitution. And that draws the court into the process of drawing or redrawing the line, if you like, which means that the court is kind of directly implicated in the process of legislating, which is a process that is consigned to the Oireachtas by the Constitution and for good democratic reasons. She says, and I think it's probably maybe the most important paragraph in her judgment, or paragraphs 167, 168, 167 and 168 really. You can see there in paragraph 168, she says, I find it impossible to see how the test could be carried out in a manner that would not result in the process of litigation becoming an established part of the process of legislating. And later on down in that paragraph, she says, direct resort to a proportionality test would seem to me to put the courts into the position, or in the position of another house of the Oireachtas, with the power not only to overturn the choices made by the elected members, but in effect to alter such choices and to create new legislation based on the judge's view of what the more proper choices would have been. And that brings us back, of course, to Henchy's rationale for the rationality test, his reasoning for the rationality test in the first place in Delan and the Attorney General from 1980. In other words, the view of the judge or the view of the court as to where the line should be drawn is actually irrelevant, because they have no insight into that question any more than anybody else does, in the sense that it's a political question fundamentally, which is why I suppose ultimately, the test should be a rationality test rather than a regular proportionality test. I just draw your attention, I won't read through it now, but I draw your attention to paragraph 172, where Iseult O'Malley elaborates further on the consequences of the proportionality test applying in these kinds of cases. It would mean effectively that the line would keep being redrawn by courts, which would mean, why would you not extend the line so as to include the family in the situation in question? Why would you not extend it further and to say, well, look, anybody who has a child, not even with a disability, but with injuries that are very serious and that require particular care, why wouldn't they be included? And then you could extend it out beyond that again and so on. The point is that the court would now be doing the legislating and would be taking over the role of the Oireachtas, essentially, which is problematic from a constitutional and democratic standpoint.